Hi, my name is Keramet Reiter. I'm a professor at the University of California, Irvine, and it's my honor to be here today with this amazing group of scholars and advocates and activists who study solitary confinement in the United States. I'm going to go ahead and share my screen so you can see my PowerPoint presentation now. Um, and Today, I'm going to be talking about the potentials and challenges of reform efforts. And I should say, I might at times come off as a little bit negative, but my goal in discussing these things is to talk about, definitely to highlight some of the successes that reform efforts around solitary confinement have had, but also to highlight the challenges and limitations of those reforms in order to help us to think about a path forward, right? What's still left to do, and how can we avoid some of the limitations of earlier reform efforts? So, why talk about reform? I'll start here just with two kind of archetypal examples of what solitary confinement looked like in the United States just a few years ago. One is a prisoner's drawing of the security housing unit in California, or at the Pelican Bay Supermax. So this is a drawing of one pod on that unit, 4 cells on the bottom, 4 cells on the top, prisoners looking out from a cell the size of a wheelchair accessible bathroom stall out at a blank white wall, fluorescent lights in their cells on 24 hours a day. And the picture you see on the other side is a picture of how prisoners would be held if they were ever allowed out of those cells for any kind of human contact. They were often put in these cages, which California euphemistically calls therapeutic treatment modules, in order to participate in therapeutic treatment, to go to the law library, any kind of interaction that they might have at all from these isolation cells would be in these cages. This was just a few years ago in California and in many places in the United States. And that has changed drastically over the last few years. So here's where I say there's a lot positive about what's happened with reform around solitary confinement. So this is a picture from just about a year ago in California, in that same pod that you see this prisoner's drawing of here. There are prisoners out with their arms around each other's shoulders, and they've painted a gorgeous, vibrant, multicolored mural on what was a blank white wall. That is because of reform efforts. The Pelican Bay Security Housing Unit is no longer a long-term isolation unit. It's been converted into a low security unit. Prisoners are able to come and go. Those cell doors remain open all day long. And they're doing things like literally painting murals on these blank concrete walls. Likewise, in many places, including in Washington State, which I'll talk about briefly today, these cages have been replaced with a device called a programming chair that allows prisoners, even in long-term solitary confinement, to sit at a desk and face another prisoner, sit in a circle, maybe even share a meal, certainly talk about a book they've read, or talk about challenges they're experiencing in segregation. And so that's very different from being locked in a cage, to be sitting at a desk like a student in a classroom. So the question is, what brought about these reforms, and are they as awesome as they seem, right? These are two, to me, really powerful images of drastic changes in individuals' lives. And one of the themes I think you'll hear me talk about today is that these reforms have made concrete differences for individuals, but often they've left the troubling institutions intact. So I want to talk today about 3 moments of potential reform. And I say potential because there was great hope about what reform would happen. Some things did change and some things didn't. So those 3 moments are 1990s litigation in California in the case of Madrid v. Gomez, 2010's advocacy in California when prisoners coordinated hunger strikes, and then ultimately this led to the settlement in the case of Ashker, which I'll talk about, and then administrative reform in Washington State, which I'll touch on briefly. So I'll start with the 1990s litigation in California in the case of Madrid v. Gomez. So Madrid was a case brought as soon as Pelican Bay, which I showed you the pictures of, opened in 1989 in California. And the case challenged the very conditions of confinement in this long-term solitary confinement unit, this facility that was built to keep people in isolation indefinitely. And the first instinct about these conditions, and one of the things that came up right away, was that in 1890, the US Supreme Court said, in an aside, it was not a case explicitly about solitary confinement, it was a death penalty case. But in an aside, the US Supreme Court said in Irvine that solitary had been abandoned in the United States. And yet we get those long-term solitary confinement cells I showed you in those first pictures at Pelican Bay in California in 1989. What's going on? Prisoners start challenging the conditions of confinement immediately. And over the course of the 1990s, there are a few exposés of how horrific the conditions are at Pelican Bay. And there's a class action case brought before Judge Henderson, known as an incredibly liberal judge, sitting in the federal district court in San Francisco in California. And prisoners talk about excessive force, sensory deprivation, inadequate medical and mental health care. And the conditions are so bad that 60 Minutes goes and does an expose. One of the really striking stories out of Pelican Bay was about a prisoner who smeared himself in his own feces and then was dipped in scalding water until his skin peeled off. And that was one of the things that motivated Mike Wallace of 60 Minutes to go to Pelican Bay and look at what was happening there. In the case of Madrid, there were a couple wins. Judge Henderson ultimately found that excessive force was being used at the prison. Things like what happened to Von Dorch when he was burned and his skin peeled off, not acceptable, violates the Eighth Amendment, right? Kind of don't have to be a lawyer to understand that. Similarly, the inadequate medical and mental health care at the prison was a real problem and has led to continued litigation and reform in California over the last 30 years since Pelican Bay opened. But that question of whether the conditions themselves in indefinite solitary confinement in the state were unconstitutional, exemplified by the concept of sensory deprivation, that Judge Henderson ultimately said was okay. The conditions at Pelican Bay didn't of themselves violate the Constitution. So in terms of that core question, are supermaxes constitutional? Judge Henderson ultimately said yes, and Pelican Bay continued to exist with prisoners spending, when Madrid was decided in 1995, some prisoners had been there for 6 years, but the clock ticked on, and some prisoners were there for continuously for 10 years, 15 years, 20 years. And so the first question here, right, is we've got some wins with Madrid. We've got improvements to the conditions of confinement, but we have some limitations. We have people continuing to spend years at a time completely alone in an 8x10 concrete box with fluorescent lights that are never turned off. Those conditions are really important and I think help us to understand the limitations of Madrid. Prisoners, when Madrid was brought, called Pelican Bay Skeleton Bay because the conditions were so harsh. In the end, the reformed institution that existed by the end of the 1990s with oversight from Judge Henderson and the lawyers who litigated Madrid, it no longer is called Skeleton Bay, right? People call it Pelican Bay. And part of the challenge of the institution, I think, is that it looks so neat and clean. You have this poured concrete cell with these lights that are always on. It's easy to clean up. Even when you have someone like Von Dorch who smears feces over himself and over his cell, you can hose it down, clean it up. There's a toilet, there's a sink in the cell. Again, it's not dark. And I think the contrast between what we might think of as isolation in Irvine Medley in that original case when the Supreme Court talked about solitary confinement, where we were talking about solitary confinement literally in a dirt hole in the ground, without adequate light, without running water, without adequate food. And what we have at Pelican Bay is a sustained effort to meet the absolute minimum conditions of confinement. And it turns out it's hard to resist something that looks so clean and neat and where we don't always see the harm that the prisoners are experiencing. And that's a lot of the work that I think people will be talking about at this conference over the next few days is all of the social and scientific work that has gone into documenting the non-physical harms that prisoners, or even the physical but non-visible harms that prisoners experience in long-term solitary confinement. But it has taken decades to build that body of work. And at the time Madrid was decided in the 1990s, it was hard to know exactly what the harm was of this clean, neat cell. It was a psychological harm that we were just beginning to understand at the time. And so it was hard to declare the conditions themselves unconstitutional. Easy to say you can't beat up prisoners, you can't dip them in scalding water, you have to provide them basic health care. Much harder to say you can't leave them alone in a cell for 20 years without the body of evidence we've started to collect. So fast forward 20 years to these prisoners who have spent this time continuously in the Pelican Bay Security Housing Unit, or SHU, since Madrid was litigated in 1995. And we have increasing unrest and frustration with the conditions of confinement and the hopelessness that these prisoners will ever be able to get out. And a bunch of prisoners, some of whom were involved in the Madrid litigation in the beginning, organized to coordinate a series of nonviolent hunger strikes out of the Pelican Bay SHU to protest these conditions of confinement, especially the indefinite nature of the conditions. So in 2011, 6,000 prisoners participated in a 3-week-long hunger strike. 2013, 30,000 prisoners participated, some for as long as 60 days, refusing food to protest the conditions of confinement at Pelican Bay. So of course, some of the prisoners are in Pelican Bay, and Pelican Bay has 1,056 beds, or had, for long-term solitary confinement. And some of the prisoners are within the prison system across the state of California, protesting these conditions. And on this slide you see here, you can see some of the things they were asking for, but many of the requests revolved around this idea that prisoners were being punished based on their status as gang affiliates. And they were asking for procedural reforms to open up some possibility that they might be able to be released from solitary confinement indefinitely, along with some really minimal requests about improvements to conditions of confinement, like asking for adequate nutritious food, asking for a wool hat that they could wear when they went outside for an hour a day into an exercise yard alone, asking for some kind of programming, like maybe colored pencils so their drawings wouldn't be in black and white like the one I showed you. So really limited, moderate requests they're making. And the coordinators of the hunger strikes, it's important to understand, came from across alleged gang affiliations in this state. So the leaders of the hunger strikes were alleged to be members of gangs that state prison officials said were arch rivals and enemies who would never collaborate on something like this. So that was a really powerful aspect of the movement, was that these prisoners who were alleged to be arch enemies were coming together and coordinating for a non-violent protest movement. And so here you see a number of the prisoner leaders and the gang affiliations the state alleged they had, from the Aryan Brotherhood to Mexican Mafia to the Black Guerrilla family. Two I'll talk about in particular, you see Todd Ashker and Danny Troxel there on the left-hand side, and those were two of the leaders. The settlement that I'll talk about bears Ashker's name as one of the ultimate leaders of a class action about this. So the really important thing to understand about these prisoners is that I told you they wanted slight improvements to the conditions of their confinement. They also wanted procedural changes to make it possible, to give them some hope that they might someday be released from solitary confinement. That was because in California, at the time of the hunger strikes in 2011, all that was required to be replaced indefinitely, indeterminately at Pelican Bay, in that security housing unit I showed you, was 3 pieces of evidence that you were a gang member. And those 3 pieces of evidence, the easiest way to think about what might qualify as evidence of gang membership is anything that we outside of prison might think of as a First Amendment right. Something you drew. So here's an example of a prisoner who allegedly had drawn a Mexican mandala. That would be considered evidence potentially of Mexican Mafia membership, or membership in another Latinx prison gang. Your tattoos. So some of these tattoos are admittedly troubling, like the swastika, but even a clover could be considered evidence of membership in a white power gang. What you were reading, Malcolm X's autobiography, The Letters of George Jackson, would be considered evidence of membership in a Black guerrilla family. Letters you write, people you socialize with on the prison yard. Any 3 pieces of evidence of basic kind of exercising what outside of prison might be basic First Amendment rights, what you read, what you write, what you draw, what you say, could be considered evidence of gang membership. And once you were labeled a gang member in the California prison system, up until the Ashker settlement, you could be sent to solitary confinement indefinitely. So that was one of the core things all of those guys I showed you here were coming together collaboratively to protest, was this idea of this gang validation process through this very discretionary set of 3 pieces of evidence. As the hunger strikes happened, one of the first really powerful impacts of the strikes was that they brought attention to Pelican Bay. For the first time since Mike Wallace had visited in 1993, journalists entered the facility, pictures came out about the facility. The United Nations Special Rapporteur on Torture wrote a report about the facility. Journalists started to ask questions, and this chart is key. For the first time, California residents and lawyers and advocates learned that there were more than 500 prisoners, so the sum of these 3 bars here, more than 500 prisoners who had been in Pelican Bay continuously for at least 10 years, some for as long as 20 years. So this was a powerful moment of insight, right? And this is one of the things I will say about these moments of litigation and reform is that to the extent they bring transparency to these institutions, that is incredibly powerful. And the more sustained that transparency and oversight is, the better. And that's because we find things out that we didn't know. I'd been asking for data like this as a scholar of solitary confinement in the state of California for years before the hunger strikes. And as soon as we know that there are 500 prisoners who've been there more than 10 years, that means there's a class of people about whom we can advocate and say 10 years is too long, and think about who are those people? Can we identify them? Can we seek reforms in the conditions of their confinement? And that is indeed what happened with the Ashker case. And over years of litigation, ultimately the state settled in 2015. And one of the big wins of that settlement was that gang validation was no longer sufficient grounds for isolation, and that the state could no longer use this discretionary process of any three pieces of evidence that we might otherwise think of as exercising First Amendment rights. No longer could the state use any three pieces of evidence like that to validate someone as a gang member. The state had to actually provide evidence that someone had broken a specific in-prison rule in order to justify solitary confinement. Indeterminate isolation was also banned. The state capped it at 5 years, and it applied retroactively. So all these guys who'd been coordinating these hunger strikes ultimately were released from long-term solitary confinement in the state. And so here's, again, a positive, right? I show you again the picture of the colorful mural on the wall of that solitary confinement unit. And then I show you a picture of two prisoners. These are mugshots of them around the time of the hunger strikes on the top, who were involved in leading the hunger strikes. A prisoner named Huerta and a prisoner named Ashker, and then those two prisoners having a contact visit for the first time in decades in a prison visiting room in the state of California. So again, really concrete improvements to individual people's lives through this case. But as with Madrid, there are real limitations to how far the reforms have gone. And again, I say this not to critique the case, right? These are really tough issues about how we reform these conditions. I say this to give us a sense, an indication of the challenges of these reforms and where we still have work to do. So three categories of challenges. Persistence, opacity, and administrative control, right? These institutions continue to exist much as they have. Often they're renamed. So RCPG, you don't even have to know what it's called. It's just another acronym instead of SHU for a unit where people are in long-term solitary confinement. So the RCPG in California is designed as an alleged step-down unit, but prisoners there are spending, again, 22, 23 hours a day locked in their cells with little access to human contact or programs like education or access to outdoor exercise yards. So that theme of creating new units and renaming them, but then keeping prisoners in segregation-like conditions is really powerful theme of persistence. Long-term lockdowns at prisons, still problems in the state with them relabeling people as gang members and sending them back to segregation. And the state's resistance to oversight, right? Much of the oversight in the Ashker settlement has happened with lawyers looking at what's happening in the state, not with anyone being able to come in and access data in the state. Another real challenge is, even though the Ashker settlement sought to directly attack that issue of people in prison being labeled as gang members based simply on drawings, readings, tattoos, and that was a way to counteract this idea that these gang members were just the worst of the worst or the most dangerous prisoners in the system. And Ashker really sought to counteract that in really specific ways, forcing the state to release those people, demonstrating how releasing them back into the general prison population, and sometimes even under the streets of California, didn't cause any moments of violence. It was phenomenal. And yet, state prison officials have continued to assert that these prisoners are the worst of the worst. They've continued to misuse and fabricate confidential information in spite of the new rules in the state that can't be used to send someone to solitary confinement. They've used that same discredited information to come up at people's parole hearings and say you're not eligible for parole. And they've even used that information that was discredited in the Ashker settlement and litigation to indict some of the very prisoners who were involved in coordinating the hunger strikes, including Danny Troxel, on new charges. And so there's all these questions about how you shift the culture of a state, right? You can change the rules, and yet the institutional cultures persist. And I think it's really important to acknowledge and understand those patterns. Um, One of the potential benefits, I think, of Ashker is all the new research it generated, right? It did create some transparency and oversight and new data. And even in the course of litigation, the scientific briefs filed in that case are phenomenal in terms of, as I suggested, for the first time, documenting what the harms of solitary confinement are that we can't always see, including psychological harms, neurological harms, really developing a body of research. But the research too is challenging. There's two challenges I want to highlight about this growing body of research about solitary confinement, of which I am a part. So I say this again just as kind of warnings, but I think there's a risk of indirect legitimization, right? There's a risk that if we go in and we research these conditions and we document how they're harmful, we're implying that perhaps they should continue to exist, or perhaps we could refine them, instead of acknowledging that the United Nations says these conditions can amount to torture. And maybe we don't, a powerful response I hear from advocates sometimes is we don't need more research to understand how these conditions are harmful. And so I think there is this challenge of, on the one hand, the research can be really powerful to mobilize. And on the other hand, sometimes it implicitly suggests that there's room for reform where we need to be thinking about more drastic shifts to the practice. And the other challenge of research, I think, is often that it tends to focus on the individual harm of these institutions and how to mitigate that individual harm. But we don't always think about the institutions themselves and the way the institutions might actually be shaping the research, right? If the institutions tell us that these 1,000 people are dangerous, then we look at them and we look at whether they're violent or not, kind of taking for granted the institutional assumption that they're dangerous, when in fact, perhaps the dangerousness is institutionally constructed. And so that's just to say, as we see more research, I think we need to think really critically about how that research is created and what it's doing. And I'll end with my final example of administrative reform in Washington state, which is a place where I've had the opportunity to do exactly this kind of research and confront these questions about whether research legitimizes a system and how we as researchers think about what the data we get from a system actually shows us, and how it's kind of pre-framed within institutional assumptions that prison systems are making. And Washington state is another nice example, because here I talk about California as a place where litigation has mobilized reform, but Washington state is a place where administrators have initiated reform, not under the threat of litigation. And so one thing Washington has done, those chairs that I showed you at the beginning, that's a major reform Washington has implemented, where they've replaced these cages with these programming chairs that allow people to actually make eye contact with each other, to have face-to-face contact with their peers in a way that really, I think, mitigates what we think of as some of the most severe harms of long-term solitary confinement. On the other hand, I think of these chairs as exemplifying the bounds of reform, because prisoners in these chairs are handcuffed, often their feet and often even their hands, to the bars on the chairs. So these are specially designed chairs made in prison industries in Washington state, just for solitary confinement units, to still lock prisoners in and confine them. And so, much like I showed you in the pictures in the beginning with how Pelican Bay looks better than a dark, dirty dungeon did 100 or 200 years before, these programming chairs look better, but I think they maintain a lot of the restrictions and controls and assumptions of the need for long-term solitary confinement that suggest how reforms are working within a very narrow set of imaginaries and boundaries, that we need to think about what those boundaries are and whether they are where they should be. One more example from Washington state. This is a chart, and really all I want you to see are the trends on this chart. This is a chart showing solitary confinement use over time in Washington state. It's actually out of a paper pre-publication that I'm working on evaluating this. And the important thing here is that Washington state has been acclaimed for their reforms, for things like implementing these programming chairs, and for their attempts to decrease their reliance on long-term solitary confinement. And this chart, like all of the things I've talked about in this talk today, has some good things and some bad things in it, right? So one thing you see on this chart is a dotted line. So the gray line at the bottom of the chart is the prison population in Washington state. And this chart is kind of centered around prison population in 2002. And what we see is that it's been fairly stable, actually, since 2002 in Washington state. While the prison population has been fairly stable, the length of time people have spent in long-term solitary confinement has fluctuated since 2002. Going up, that's the dotted line you see, going up, going up, going up, but falling over the last few years. And this is a place where Washington state has been incredibly successful, reducing lengths of stay in long-term solitary confinement over time. The other solid black line, however, is where Washington state has been less successful. And that's that their use of solitary confinement over time has increased from 2002 to 2011, that it's a 300% change increase from 2002 to 2011 in their use of solitary confinement. And while their use has fallen over the last few years, it has not fallen to anywhere near the levels at the beginning of the data I have in 2002. So it is to say that long-term solitary confinement use continues at a relatively high rate in Washington state. And I think it's important just to understand, again, another way to think about the boundaries of reform, right? Some successes. We're reducing the length of time people are spending in solitary confinement. We're reducing the overall number of people, but we're not reducing it to even the levels it was at in 2002, let alone before long-term solitary confinement was as drastic and common a practice in the United States as it is today. So I hope this has given us some fruit for thought and conversation about the various successes and also limitations and boundaries of reform, and the places we might think about continuing to work as we think about how solitary confinement might be reformed in the United States. So I look forward to the conversation and talking with you all.